I know you've all heard that the definition of insanity is doing the same thing over and over again, expecting different results. For me, that might look like having 5 separate knitting projects going at any given time and expecting that they'll be finished in a timely manner. Spoiler, they do not get finished in a timely manner. They never have, and they probably never will. For Gunnery Sergeant Bass, the repeated behavior was or could have been eating whatever gummies his wife handed to him, even after repeatedly failing urinalysis testing. This is Conduct and Becoming. I'm Erin, and I'm your host. Not that long ago, the Department of the Navy issued clarification that when it barred service members from injecting, ingesting, inhaling, or applying hemp-derived products to their bodies, the ban included hemp seeds in things like granola bars and hemp-based shampoos, conditioners, lotions, balms, and soaps. It was not the first time that one of the armed services reminded service members of the ban. It even mentioned that service members could not rely upon an ingredient list and had to be diligent in ensuring they did not violate the order. I remember that guidance being issued and reissued because there was a specific widely available protein-focused granola bar that contained hemp seeds at the time. Even though the bars were not available for sale on base due to their inclusion of hemp seeds, they were a popular scapegoat following positive urinalysis. The bars had a THC level of 0.001%, and for what it's worth, research suggests that a person would have to consume large amounts of hemp seeds in order to test positive for any noticeable amounts of THC. But large amounts is an incredibly vague metric, so I dug in. It's generally accepted that someone would have to eat 2/3 of a pound of hemp seeds to test positive, but there is some additional research that seems to suggest that up to 20% of the population could test positive at lower levels of consumption. I couldn't find whether that's a 1/4 pound or less. We've talked about the finer points of knowingly consuming illicit substances before. Think of the sugar bowl and the cocaine-laced sugar bowl from episode 62. We've also talked about the legitimate medicinal applications for popular drugs and how consuming a drug with a valid military prescription doesn't bear the same risks as consuming an illicit drug without a valid military prescription, consuming a drug for fun. There is presumably a lot more free-floating hemp seeds in the world than loose cocaine. And there are a ton of commercially available THC products dotting the shelf. At our local Bevmo, the THC and CBD products have a section next to the canned cocktails, and it's not exactly clearly delineated where one section ends and the other begins. For those of us that do not work for the federal government, it's an innocent mistake to make, and one that's unlikely to have career implications. Gunnery Sergeant James Bass first found himself at a special court-martial in October 2022 for 3 separate urinalysis results. He had provided samples on September 16th, November 9th, and November 15th in 2021. At his court-martial a year later, Bass told the panel that he wasn't to blame for his positive drug tests, that he'd ingested the THC 8 innocently. He testified that he remembered those days because they were monumental and that his career was almost going to get flushed down the drain. Bass, like Dillenberger in episode 62, blamed his romantic partner. Specifically, he blamed his wife, saying she provided THC-laced vitamin gummies. I confess that I am not often in the gummy vitamin market because the flavor labels are insufficiently clear about whether popular flavors are flavored with real fruit and might, in fact, kill me via anaphylaxis. That issue aside, I understand that there are THC gummies and CBD gummies and vitamin gummies, and that they all do different things. But I don't know if THC vitamins are really a thing. Nevertheless, the panel bought his explanation that his wife handed him laced gummies without his knowledge and acquitted him. The problem with an innocent ingestion defense is that you sort of have to learn from the innocent incident and proceed to diligently avoid whatever it was that was laced. And Bass seemingly chose a different route. Shortly after his court-martial acquittal, and I'm talking within weeks, the Marine Corps again collected Bass's urine in late October and again in mid-December 2022. Again, both tested positive for THC-8. Again, the government charged Bass for violating the order prohibiting sailors and Marines from using products made or derived from hemp. Because it certainly seemed like a pattern of behavior, the government filed a notice that it intended to use the evidence of the previous positive urinalyses and portions of his testimony from his first court-martial. They bobbled the original notice, but the military judge allowed them to re-notify defense counsel if Bass raised a defense of innocent ingestion or other mistake or accident. At the judge-alone special court-martial, a chemist testified to testing standards and described some of the market conditions and labels. On cross-examination, she said that sometimes labels were vague, but that she'd never seen a product that completely failed to disclose THC content. It's a bit technical, but she also testified that if someone consumed marijuana, she would expect to see THC-9 and THC-8, and that Bass's samples only tested positive for THC-8. This matters because when something tests positive only for THC-8, I believe that means that it's hemp alone versus marijuana, which would produce a THC-9 and THC-8 positive sample. In his defense, Bass called 3 separate people to testify to his good military character. Then, he rested. The government sought to introduce Bass's earlier test results and testimony over the defense's objection, and the military judge allowed the government to present it as rebuttal evidence because defense opened the door by asking the chemist about mislabeled goods, setting up a defense around mistakes, something the judge had specifically warned them about. Counsel for Bass argued that they had not raised a specific innocent ingestion defense. Contrasted with his first court-martial, at this second one he had not blamed his wife for giving him gummies or provided any other story or explanation as to how THC came to be in his system. But when the defense got to respond to the government's rebuttal, they called a separate chemist who testified that it could be possible for someone to use marijuana and test positive for THC-8 and not THC-9. Because Bass was charged with violating the order prohibiting hemp consumption, this kind of makes it sound like his response to the government's rebuttal boiled down to, haha, you dummies, it was marijuana, not hemp. The military judge convicted Bass anyway and sentenced him to a reduction from E7 to E5 and a reprimand. The government had encouraged the judge to rely on the permissive inference from a positive drug test that Bass had wrongfully and knowingly consumed the hemp product. The Navy and Marine Corps Court of Criminal Appeals affirmed the military judge's admission of the evidence, concluding the judge did not abuse his discretion, and further affirmed the conviction as factually sufficient. But when this all got kicked up to the Court of Appeal for the Armed Forces, it became a bit unwieldy. The paragraph laying out where the various CAF judges came down reads like an LSAT problem. They had taken up the case to decide whether the military judge erred in admitting those prior positive urinalysis results and whether the judge erred in relying on the permissive inference in order to convict Bass. And they had a variety of answers to those questions. Most of CAF held that the judge did abuse his discretion in admitting the evidence related to the earlier positive test results because the cross-examination of the chemist, the one that set up a bit of the innocent ingestion defense, wasn't sufficiently similar to the previous incident and was therefore impermissible propensity evidence. The court also issued a very interesting narrow holding that a positive THC-8 urinalysis test result alone does not, and here's the heavy lift that's going to plague these courts-martial in the future, cannot rationally support a permissive inference that a service member knowingly used hemp or a hemp-derived product. The permissive inference is a big component of wrongful and knowing drug use cases, so I do think that this fractured opinion worked hard to narrowly constrain that holding and to narrowly dismiss the permissive inference as to THC-8 only drug pops. Because the products that contain THC-8 are not a controlled substance and are available in a variety of places including gas stations, and because a positive drug test is not indicative of some psychoactive effect, the court didn't think it made sense to be able to conclude that Bass knowingly consumed a hemp product. The majority opinion then went on to say that taken together, the admission of the impermissible propensity evidence and a lack of underpinning for the permissive inference, the cumulative error denied Bass of a fair trial. As I hinted at earlier, the judges were really divided, and the variety of opinions authored on the matter are a really interesting read. Some felt the judge did not err in admitting the evidence, and many disliked the application of the cumulative error doctrine. The cumulative error doctrine is premised on this concept that there were individual errors committed, but that none of them alone were all that worrisome, and didn't necessarily merit overturning a conviction. Instead, it's sort of more like death by 1,000 paper cuts. No individual error deprived somebody of their legal rights, but a series of small errors did. And it does seem odd to apply it here, where the errors would generally be considered of a magnitude to warrant reversal. So I think throwing cumulative error into the mix waters down the rest of the holding. Either it really matters that those additional test results and testimony came in, or it really matters that the permissive inference doesn't apply to THC-only drug pops. But to say that those aren't really all that important and it's cumulative error that warrants reversal in this case is odd. I am very curious how far afield the holding will run and whether the permissive inference will be peeled away layer by layer, drug by drug, until it's booted entirely. Only time and a series of CAF opinions can tell. Thank you for listening. If you enjoyed today's episode, please share it. I invite you to submit case suggestions and feedback to conductunbecomingpod@gmail.com or on conductunbecomingpod.com. Join me next time when we talk about counseling gone wrong. Until then, take care. Conduct Unbecoming is a podcast where I get to talk about interesting crimes and cases that involve U.S. military service members. I research, write, and produce the podcast myself. The opinions expressed are my own, and perhaps it's obvious. Conduct Unbecoming is not approved, authorized, or endorsed by the Department of Defense.